Hello, this is Detective Masagi. We at yaminotante.org investigate corruption in the USA and Japan. Today I will be talking about corruption in the USA and an announcement about a new investigation type. The corruption I will be talking about is the FBI and the DOJ. The warrant on President Trump's residence is illegal. I only have to do a simple criminal justice 101 lesson to prove it. First of all, the judge or magistrate approving of the warrant needs to be impartial. Susan T. Perkins, attorney at law, says on her website, judges can have biases and those biases could get in the way of fairness. Only a neutral magistrate can issue a warrant. If he has an outside connection to the case, he could make an unfair decision. The book Criminal Justice by Adam J. McKee also stresses the importance of impartiality. He states, as a general rule, the evidence establishing probable cause must be submitted to an impartial magistrate, and if the magistrate agrees probable cause exists, then he or she will issue a search warrant. The magistrate involved in this case is Bruce Reinhart. Before he was a magistrate, he represented several Epstein associates. He is also an outspoken Trump critic. Read this Facebook post he made after Trump won in 2016. I generally ignore the president-elect's tweets, but not this one. John Lewis arguably has done more to make America great than any living citizen. Last August, I took my son to the Edmund Pettus Bridge in Selma so he could understand the kind of courage and sacrifice required to live in a democratic society. John Lewis embodies that spirit. Although I've never met him, he is one of my heroes. This magistrate also donated to Obama and Jeb Bush. He also recused himself from a Trump versus Hillary lawsuit. The warrant is invalid with even just this, but I will now explain how a warrant is conducted. Let's listen to a retired FBI agent on the basics. I disguised his voice so the communists in power can't take away his pension.
We're gonna talk about a search warrant. A search warrant is very specific. It must be signed by a judge, and they must be served to the person that is going to be the subject of the search warrant between 6 a.m. and 10 p.m. And the judge specifies on the search warrant the areas to be searched and the property to be taken. Nothing more can be taken. It is completely restricted to the area that is specified in the search warrant. After the items are collected, the person receives a copy of the itemized list of the documents or property which was taken, along with a copy of the search warrant. The search warrant does not give the police or agencies any authorization to go beyond the areas specified in the warrant. If the warrant is for classified documents, only the classified documents that are specified in the search warrant, like box number such and such, located in the room such and such, and nothing more. The police or the agency does not have the authority to go beyond the search warrant and say, well, I think there's some stuff in the other room, let's go over there. They cannot do that because it's not listed in the search warrant. It is very much restricted to the specifications of the search warrant.
Why are warrants done this way? Let's take a look at the Fourth Amendment to the U.S. Constitution. It says, the right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. This probable cause part is important too because every item that is taken needs to have some basis behind it. Garland and the DOJ knows this, which is why he claimed the warrant is narrow in scope. How narrow in scope is the warrant? It says, any government and or presidential records created between January 20th, 2017 and January 20th, 2021. That is not narrow and outright illegal. Remember, every single item needs to be backed by probable cause. What else is on the warrant? Executive grant of clemency re. Roger Jason Stone Jr. Handwritten note info re. President of France. None of this is evidence of anything and was an illegal seizure. His passports were also taken and those weren't even on the warrant. They also rummaged through Melania's underwear. As for the so-called classified documents, the president has the authority to declassify anything. Trump lawyers said they were also told to wait outside in the heat. You can't kick out lawyers. Read what another lawyer told me about these kind of circumstances. Her name is redacted so communists can't disbar her like they did to Rudy Giuliani. Attorneys can only be subjected to a search warrant when a particular procedure is held that the evidence must be seized, and they must be a specific suspect engaging in the alleged criminal activity. While there are several circumstances in that police can kick out people during the search, it is generally speaking for people to remain safe and out of the way. There are many rules about questioning and detainment, so the law does not generally encourage anyone to leave the scene during a search warrant and when it is being executed. Now the matter of kicking out attorneys is a whole other ordeal. If police are kicking out attorneys from the scene of executing a search warrant, private property or not, they cannot do this, as there is a fundamental right to an attorney during questioning in the United States. Many legal problems can potentially occur when there is unchecked police power, such as violating the constitutional right to have an attorney and to be innocent until proven guilty. Trump lawyers, including Christina Bobb, only managed to see the warrant after arguing with the agents. Let's see what this legal website says about not showing warrants and throwing people out in the heat. Courts generally frown on officers who fail to exercise even the most basic courtesy to cooperative people during the execution of search warrants. For example, officers aren't supposed to enter your home, refuse to show you the warrant, refuse to allow you to get dressed, then keep you outside in the hot sun for 5 hours without anything to eat or drink. Nonetheless, in one case, that's exactly what alcohol, tobacco, and firearms, ATF, agents did to a woman when they executed a search warrant at her home. U.S. v. Thompson, 667 F sub. 2D 758, SD Ohio 2009. Let me also let you know that any so-called evidence collected illegally is not admissible in court. As you can see, nothing was done correctly and the FBI violated President Trump's constitutional rights. The warrant is not valid and the stuff they took was illegally seized with no lawyer inside and is therefore not admissible. This is the same FBI that encourages voter fraud. Therefore, I am offering a new investigation type. That is address verification. This is done by looking at utility records of the target. This type of investigation is available for USA Investigations and is on yaminotante.org. If you want to order on Fiverr, you will need to message me for a custom offer. Address verification can technically be done in Japan too using different methods, but it is more expensive, so you would need a special order by contacting me first on yaminotante.org or Fiverr. This is Detective Masagi signing off.